Okay. Well, let's get started then. So, for those of you who think that TikTok doesn't work, I actually met our speaker today through TikTok. I saw her videos on asset protection, and I reached out and contacted her. And so that was a little while ago. It was like maybe 4 months ago, maybe.
It was in the summer.
Yeah, yeah. So we're glad to have you here. And so this is Britney Cohen. She specializes in estate planning and trusts. And Brittany, I'll just let you introduce yourself and start going. And I'll if anybody has questions, feel free to put them in the chat, and I'll just judiciously interrupt Brittany, or we can leave them towards the end. Your choice.
I guess we can answer them or you let me know them on the fly. And if I know that a slide is going to touch on them, I'll just say that question will be answered soon. And if it's a question that can be easily answered without like a long tangent, then I can jump in and answer it. Otherwise, I'll save it for the end.
Okay, cool.
Well,
All right. Welcome to the club.
thank you. Well, welcome to everybody who is here. This is an asset protection estate planning seminar. We will talk about 5 levels of asset protection for real estate owners and investors. My name is Britney Cohen. And this wouldn't be a legal presentation without a disclaimer that this is for educational purposes only, and you should always consult an attorney about your specific needs and a tax professional about your specific scenario. And so I always start my presentations with the best way to learn is, and the best way to get the most out of your time is to, turn off your phone and minimize distractions. I know it's hard in this day and age, but it really is the best way to get the most value out of your time today, and your family deserves it. So my first question is, do you currently have an estate plan? An estate plan can range anywhere from a will or a trust to powers of attorney, beneficiary designations, or life insurance. Everybody's definition of an estate plan is personal to them, but those are the basic kind of fundamentals of estate plans. And if you don't have an estate plan, you are in good company because 70% of Americans do not have an estate plan in place. And if you don't, why not? Some common examples or reasons that I hear are that, you're too busy, or you're too young, or you feel like you don't have anything to protect, or you just put it on your proverbial to-do list and it just never made it to the top. And that's okay. But if you do have an estate plan, what do you hope to learn today? Are you hoping to just get a better understanding of what you put together? Maybe you put one together by yourself on like a do-it-yourself service, and you want to know if it's going to hold up for you. Or maybe you did it, 5, 10, 15 years ago, and a lot of things in your life have changed, and you want to see if having an outdated plan is going to still function. So you really are in the right place if you have someone or something that you care about and you want to protect. If you did a fill in the blank will, but you're not sure if it will work, and you're nervous about how much it will cost. I'm seeing some chats, and I'm sorry that I'm probably not going to look at the chat box throughout my presentation. I'll look at them at the end. But the reality is that estate planning is not about you. It's about the people who you love the most, because you won't be here when we need your estate plan to work. But it's the people who you love, your family, who will really know that you lived up to your promise of, I took care of it. And so I want to start off by just giving you a little bit of background about who I am and why I'm so passionate about estate planning. The photo on the left is my 4-legged son, Indy, my dog. The picture in the middle is my immediate family, my parents and my sister at my law school graduation. And the picture on my right is my grandparents, my mom, and her sister, my aunt. And my family has always been my biggest support system. And when I told them that I was going to law school, they were not that excited, because these are people who had bad experiences with lawyers. They didn't really trust lawyers. They thought that lawyers were greedy and so forth. And I share that with you because I am the first lawyer in my family. And I'm really cognizant that many of you may have the same feeling about lawyers. So I want to make that shift for you and make you feel comfortable working with a lawyer and make legal tools accessible to you. And my why. So why I'm passionate about estate planning is because I witnessed the failed estate plan. Statistically, 70% of estate plans fail. And by fail, meaning families end up in court and in conflict despite having put a plan together. So 20 years ago, my grandfather went to one of your traditional estate planning attorneys. He paid $5,000 for a one-time transactional experience. So if you've ever worked with your traditional estate planning attorney, you usually go in, you sign a bunch of documents, they have no idea what you're signing, you take them home, you put them on the shelf, you never look at them again, and you have no idea if they are going to work when you need them to work. As your life changes and as the law changes, that attorney does not reach out to you to let you know, hey, it's time to make some changes, and you don't really even know if anything needs to be changed. You probably didn't even look at it to see if things were properly funded into your trust. And that's what happened to my grandfather. He had assets in multiple states. He also had a business. And after he and my grandmother both passed away, it turns out that, the properties were not funded into his trust. And so my mom and my aunt had to go to probate court in 2 states, spending thousands of dollars and costing them a lot of time. And it wound up creating a lot of conflict in my family. And so all of this could have been avoided with, the attorney taking some extra time to check in every few years and making sure that the estate plan was up to date. So that is a little bit about my why. And I have been featured as a Super Lawyers Rising Star. I've been featured in Yahoo Finance, MoneyWise, and Daily Mail. So just a little bit about me.
Britney,
yes.
I realized earlier I was on mute, but feel free not to look at the chat. I'll monitor it for you. And we already have a couple of questions, but I'm going to save them till a little later in your presentation.
Okay, cool. Thank you. So topics that we are going to cover is, what will happen if you have no estate plan in place, why a will is not enough, the concept of multi-generational estate planning, why probate avoidance planning is not enough, asset preservation planning, and asset protection planning techniques for real estate investors. And truly my hope today, after today's presentation, is that you start thinking about estate planning differently from a more conscientious perspective of value added. How do I add value to my beneficiaries? Because a lot of people hold the belief that, well, I'm passing down money and wealth, and that alone is enough. That is adding value to their life. But should a 12-year-old get $1 million and a piece of property that they have no idea what to do? Or somebody who has like proclivities towards like gambling or substance abuse, would a lump sum of money that fell into their lap really be beneficial for them? And so maybe not. Somebody who's never owned a home, should they inherit a portfolio of rental properties? And would you consider that value added? So I really want you to I hope you walk away at the end of this thinking about this from a more conscientious perspective of your specific family dynamics. So,
Britney, one question that's come up that you could probably address really quickly. Some people in the audience want to know if you're planning on allowing us to have a copy of the slides when you're done.
Sure. My notes are
Up to you.
Yeah, no, my some of my talking notes are at the bottom, but you're welcome to have them.
Okay.
Yeah. So what happens to your assets if you die or become disabled and you don't have a plan in place? So if you don't have a plan, the state has a plan for you, and that is probate court or guardianship if you're disabled. And the concept or the process of probate court usually lasts anywhere between 9 months and 24 months, depending on the complexity of your estate and how backed up the courts are. It winds up taking about 5% of your gross estate's value. So if you add up, the fair market value of your house, your investment accounts, your business, and so forth, and let's say it was $1 million for easy math purposes, your family is going to spend roughly $50,000 going through probate court. And I like to consider probate court as a lawsuit that you filed against yourself with your own money for the benefit of your creditors, because truly the money you have to spend first goes to executor fees, then attorney's fees, then appraiser fees, then filing fees and bond premiums, and then their creditors get paid. And then any Medicaid, anything that Medicaid paid for, anything that goes through probate, they get paid, reimbursed from. And then whatever's left goes to your beneficiaries, all of which could be avoided with proper planning. So the number one misconception that I hear is that, well, I have a will, so my family is taken care of. And a will alone is not enough to keep your family out of probate court, because essentially a will is just a set of instructions for the judge that tells the judge how you want your assets to be distributed after your death, but it actually doesn't provide the legal mechanism to take the assets out of your name and transfer them into somebody else's name. So if you think about it, while you were alive, if you wanted to give something away to somebody, you would sign a contract or you would transfer over the deed. I am giving this property to my kid. We sign on the dotted line and it goes to that person. Well, when you die with assets in your name, probate court is the forum in which we need court supervision to take assets out of your name and give it to somebody else. And it's expensive and it's tedious. So this concept of multi-generational estate planning. I don't know if my face is just blocking things. So the concept of multi-generational estate planning, whether your estate is large or of modest size, if you think of it in multi-generational terms, you should consider multi-generational estate planning, because it can be really beneficial to the people who you love. And it's no longer about just avoiding probate or minimizing taxes. It's about creating something that will last for generations. So it's multi-generational estate planning is the passing of wealth for more than one generation and building wealth with the plan of passing it on to future generations is important, because it can really help them with financial foundation to live a comfortable and secure life. And how do you protect this wealth for multiple generations? What about divorce, lawsuits, and taxes? So statistically, 70% of wealthy families lose their wealth by the second generation, and 90% of families lose their wealth by the third generation. And why is this? Well, oftentimes parents don't want to talk about money with their kids, or grandparents don't want to talk about money with their kids. Second and third generation heirs don't understand the value of money. And if they've never had to earn it themselves, they really are usually not equipped to continue to manage and preserve it. Or the worst thing is that families just neglected to set a plan for preserving their wealth, because having family wealth and preserving it are two different things. That's why those statistics are so stark. Preservation requires careful and considerate planning. So what is a trust? There's a lot of different types of trusts, but the most basic form of trust that we talk about in foundational planning is a revocable living trust. And you can think of it as a substitute for a will that avoids probate court. No, I'm not familiar with financial planning ministry. Sorry, I just saw that pop up. So in the 1980s, we were all, how estate planning started, we were really worried about avoiding probate court. And now we have kind of evolved where that's just simply not enough. So what about protecting the inheritance from threats, financial elder fraud, long-term care costs, divorce, creditors and predators? And a lot of times right now, many attorneys are focusing just on avoiding probate court, and they're doing a disservice to their clients because they're not looking at the bigger picture. Because federal estate taxes. So federal estate taxes, also known as the death tax, is the tax of a deceased person's assets. And as you can see from this chart here, when the Trump administration took office, they raised the federal tax exemption significantly up to 11.1, and it has steadily increased. Now it's at 12.92. So that means an individual has to have an estate that exceeds 12.92. Sorry, that an individual has to have an estate that exceeds $12.92 million, or a married couple, $25.84 million, to be taxed at that 40% bracket. So if they are below that number, we're not worried about federal estate taxes, and not many people in the country are in excess of these thresholds. Now in 2026, it is set to sunset, to go back down to the pre-Trump administration numbers, adjusted for inflation. So probably going to be between 6 and 7 million. However, still, for the most part, what we're seeing is more and more people have highly appreciated assets, real estate that has gone up significantly in value, retirement and brokerage accounts that have grown significantly. And so how do we do planning that is more concentrated on capital gains tax planning as opposed to federal estate tax planning? So when I meet with clients and we're talking about planning, if it's a married couple, there's what I call the cardinal rule of estate planning. Cardinal rules, there's 3. I don't know how much money you're going to have when you die. I don't know what the federal estate tax exemption will be when you die. And I don't know what your heirs will have when they die, what their situation is going to look like. So when we plan, I always start with, you have 2 options. The first option is at the death of the first of you, because we're in California. California is a community property state. That means anything that you guys own while you're married, or that you own prior to marriage but used towards the community. So like if you started a business before you got married and your business continued to grow while you were married, some of that appreciation, some of that business's growth is considered community property. Now, you need forensic analysis to trace that back of how you really do the math, and I'm going to stay in my lane here. But when you die, so it's no longer 50, you husband and wife don't own 50-50. Husband and wife each own 100-100. It's as if you are one person. So at the death of the first of you, the first option is everything that the decedent, the person who died, all of their separate property and 50% of their community property interest can go to the surviving spouse. The surviving spouse can have full flexibility, full control over everything that you guys have owned collectively and everything that the person who died owned separately. And if you really trust your spouse, this is the easiest option, because they can do whatever they want with it. If their estate is going to be really high in net worth, they can choose to disclaim a portion of it for estate tax exemption reasons. And it's really the easiest option for them. Now, the downside to this is if your surviving spouse gets remarried, they can give your money away to their new partner. If the surviving spouse is not that great at managing money, they could burn through all of the assets, or they could make poor financial decisions. If they get sued, the entire estate is vulnerable to creditors and bankruptcy, and they could also change the beneficiaries. So if you trust your surviving spouse to do everything exactly as you would do, this is the easiest option. Now, the other option is you could choose that at your death, your estate is going to split into 2, you can think of it as buckets. Half of the bucket is going to go to the surviving spouse. That's their separate property, and 50% of the community property. They can do whatever they want with that. And then your 50% of community property and your 100% of separate property, the person who died, gets protected and locked up in an asset protection trust, in a credit shelter trust. This means that we can ensure that at least 50% of the community's estate will be protected and preserved for the ultimate beneficiaries, for the next generation. If the surviving spouse gets remarried, they can't touch, what's in your bucket. If the surviving spouse gets sued, creditors can't touch what's over here. If the surviving spouse, spends all of their money, that's on them. And really, it's a preservation mechanism to allow for at least 50% of the assets to go to the ultimate beneficiaries. Now, it also, if you make an election, this is going to get a little technical, but basically all you need to know is that as soon as your spouse passes away, you have 15 months to talk to your CPA or attorney to file something with the IRS. If you do it timely in 15 months, the assets in both the person who died's estate and the surviving spouse's estate will get basis adjustments so that you can reduce your capital gains by also get asset protection. So there's a lot of benefits in doing it this way. However, it is more expensive on the administration side because we have to take inventory of the entire, estate, get everything appraised. We have to work with more professionals, accountants, appraisers, attorneys to make sure everything is done correctly. And we can make game time tax planning decisions at that first death. So going back to those estate planning cardinal rules, since we don't know what the federal tax exemption is going to be at any given time, or any other tax rules for that matter, this gives the most flexibility and discretion at the time of death to be able to make decisions for your family. There's also a way to say that if the surviving spouse gets remarried, it's required that they get a prenup before they can touch anything in that credit shelter trust. So this is a really good option for more often people who are in their second marriages, blended families, or just people who are like control freaks. They want to make sure that things go according to their plan. And we all know them. So how this would work in like a blended family situation, right? John and Mary are married. John has 2 children from a previous marriage, Alex and Bella. And John wants to make sure that Mary, his wife, is financially secure if he passes away first. But he also wants to ensure that his children, Alex and Bella, will inherit his assets after Mary dies. So they choose option number 2, which means that if John dies first, his assets are placed in a separate trust for Mary's benefit. Mary will receive all of the income generated from those assets in the trust for the rest of her life so that she has some financial support. And assets in that trust could be, rental properties, dividend paying stocks, bonds, CDs, savings accounts, income distributions from partnerships or private companies, REITs, or fixed annuities. And so Mary will have the right to income from this trust, but she can't decide on the principal's final disposition. The principal will remain in that trust. And then upon Mary's death, whatever's remaining in that asset protection trust will be distributed according to John's wishes. And the tax benefits here are that the assets in this credit shelter trust are not subject to estate taxes upon John's death because they are now considered to be a part of Mary's estate. So it's really a estate tax deferral strategy. I'm looking at the comments here. Who manages the assets within option 2? For example, Mary can't control the assets. So Mary can still be the trustee of both trusts, with the caveat that if she gets remarried, the only way she can remain as trustee is if she gets a prenup. And she can always appoint a third-party independent trustee within to be the person who manages the assets. It has to be within the IRS definition of independent, meaning not related or subordinate. So somebody who can make more third party, who has no beneficial interest in, making management decisions. For option 2, no step up in basis until Mary dies. Correct. That's usually when the basis, yeah. Who makes sure that the rules of the estate are enforced once a trustee is handed over the estate? Well, the trustee has a fiduciary duty to manage everything. Well, we're going to get to that in a second, but essentially, beneficiaries are entitled to copies of all of the estate planning documents, and if they feel like they are not being treated correctly, they can they have a fiduciary, they have a legal claim against the trustee. So they could remove the trustee depending on the terms of the trust, or they can sue the trustee if some egregiousness is happening. So when would option 2 be considered for non-blended families? So if you want to have control over financial asset distribution, I ran the scenario down with my mom, and my mom was like, yeah, I would want to make sure I had control. I don't trust your father. They've been together since they were 16, by the way. So no reason not to trust one another, but my mom's just a control freak. So husband and wife want to ensure that their wealth eventually goes to their children and not future spouses, should either of them remarry after the other's death. Tax planning would be another reason why non-blended families would consider this option. If they want to maximize their estate tax exemptions to pass more wealth to their heirs, this credit shelter trust created at the first spouse's death can utilize the deceased spouse's estate tax exemption, deferring the estate taxes until the death of the second spouse. Protection from creditors or legal issues. So one or both spouses are concerned about future creditors or legal liabilities. Maybe one of them is a business owner, and would be more vulnerable to certain types of lawsuits. Or maybe they just have really charitable intentions. They want to make sure that they can give things away, but also provide for their surviving spouse. So that's option 1. As we talk about what should happen at the death of the first of you, if in a married couple, because you have the most tax planning options for married couples. As a single person planning, you don't really have federal tax strategies within your foundational planning. You're going to have to set up extra trusts, such as like irrevocable life insurance trusts or charitable remainder trusts, and a lot of other trusts that we can do in a different meeting maybe. So after the death of both of you, we again go back to 2 options, assuming you have children or beneficiaries. So the first option is that you can give all of your assets after both of you pass away to your kids outright. They've received their inheritance in their name, meaning you can do it. Hey, as soon as if my kids are 21 when I die, they want them to get their entire inheritance upon turning 21. You can stretch it out, ages and stages. I want them to receive 1/3 when they turn 21, 1/3 when they turn 30, and 1/3 when they turn 35. If they are all over the age of 35 when I pass away, then they are entitled to receive the whole thing at that time. This option is obviously the easiest option and requires little foresight in planning. Again, you are giving the beneficiaries utmost flexibility and control to do whatever they want with their inheritance. And it's the most cost effective because you don't have to really plan for what should happen in the future. But if we go back to the concept of multi-generational estate planning, this could be a reason why a lot of wealth is gone by the second or third generation, because they just spent it all or lost it. So as soon as your beneficiary takes title to these assets in their name, it's subject to their decision making. If they get married and divorced, they could lose their inheritance in a community property state. If they get sued, they could lose their inheritance to a lawsuit or a creditor. And if they file for bankruptcy, they could lose their inheritance in a bankruptcy discharge. So,
hey, Brittany, would it be a good time to pause and
sure.
have a few questions?
Sure.
Okay. And
everybody here, my internet connection just dropped and I lost my entire chat history. So if you have a question you really want me to put there, I remember a few of them, but if you could retype it, that'd be very helpful. And I remember Ains' question was number one here. Ain has moved to a different state. Should he or she redo their estate plan for that new state, or does it not matter?
So I always recommend that you have it at least reviewed by an attorney in the state that you move to, because some states are just really different from one another. California does not have state inheritance taxes or state estate taxes, but some other states do. For example, like Florida and Texas do things very differently than how California does. So it's always in your best interest to consult with an attorney in the state where you currently live, because the state that you die in is the jurisdiction that, will be executing the terms of your estate plan. So you just don't want to make it any messier on the back end for your heirs.
Okay. And Najendra has a question, which I think might be pertinent to a lot of people here. Can the trustee be not a citizen of the United States? Is there a case with jurisdiction in that situation?
Great question. Generally speaking, we do not want to name trustees people who are not United States citizens. If you select a trustee who is not a citizen of the United States, you could be subjecting your entire estate to much higher tax consequences. The reason being is that because the trustee has the fiduciary duty, the IRS looks at the trustee as the person who has control and ownership over all of the assets. And if the trustee is not a citizen, then there's no court in the United States that has jurisdiction to be able to force that trustee into court to hold them accountable for their actions.
Okay. So it's really recommended that they be a citizen.
Correct.
Yeah.
You don't have to be in the state that you live in, but they should be a citizen.
Okay. And I remember that Glenn had a question here, and I was going to elaborate on your question a little bit. His question was, don't rich people just assign their assets to another person? I was going to enlarge that question a little bit and say, what's the advantage of a trust over just creating like an LLC and putting your assets in there and having your descendants or your heirs be part of that LLC?
Sure. Okay. So the assignments question, to kind of truncate that, is how estate taxes work when you die is that any interest that you have into something, whether it's tangible or intangible, if you have an interest in it, it is part of your estate. So when you assign something to it, it really depends on what that assignment looks like and how that assignment is actually being drafted. And whether these are getting really technical, but if there's like a power of appointment that has been created, you could give your worst enemy, you could put an estate plan together that says, like, I'm giving my worst enemy a general power of appointment. My worst enemy now has enough ownership over whatever that asset is that I'm giving them they're going to be part of their taxable estate. They don't even have to know about it, but that's how these kind of technical ownership interests work. Now, an LLC, if you didn't have a trust, now, if it's a single member LLC and there's no like buy-sell agreement in place, you technically just still died with an asset titled in your name. And how do we take the asset out of your name? We have to go to the probate court, and going through probate court for a business entity is much like being audited. So it's unenjoyable, expensive, and tedious. And so it still didn't take anything out of your name, technically speaking.
All right, I'm going to do two more questions. They're quicker, and then I'll let you go on with your presentation. But Brianna's asking, you mentioned that the state you die in is the state that has jurisdiction. Does that mean the state you currently reside in when you died, or if you were in a different state and dropped dead, is it that state?
Right. Okay. It is the state that you are a resident in when you die. So even if you got into an accident in a different state, but you are domiciled, your legal residence is in, California, then California is the state that has jurisdiction over you.
Okay. And I'm actually going to add one more question in here. And following up on the trustee question, can the beneficiary be a non-citizen?
Yes, absolutely.
Yep. Okay. And then I'm jumping back up to you, Ashish. I see you in the chat. Brittany, what do you recommend when both spouses are alive and want to set up or update their estate plan? I'm sorry, both, are alive. So I think, and correct me if I'm wrong, Ashish, was this when we were talking about divorce? So they're divorced and alive and they want to update together?
No, so Brittany, you've covered what to do when one passes away or both pass away. Maybe the next slide is when you're both alive.
Oh, so when you're both alive, you set up, your if you're in a community property state, it'll most likely be a joint revocable living trust. And essentially, the revocable living trust is a see-through trust. So it just the trust identification number is either one of your guys' social security numbers. And so you fund your trust by just retitling your assets into the name of your trust, but you guys are both the trustees while you're alive. So you continue on your life as if you didn't have a trust. Virtually nothing in your life changes because the trust is not even recognized until you die in terms of like it's sometimes referred to as an entity, but the best way to really think about a trust is a legal arrangement that is prepared for your death.
Okay.
I hope
We do have a few more questions, but I'll let you go on with your presentation for a little bit. We've got 18 minutes left.
Oh,
Did you say something, Ashish? You want to say
Yeah,
something?
Brittany. So once you set up a trust and you put all the assets in the trust, that's it. You've got the exemption.
Yeah, you can buy and sell assets directly from your trust. Your trust holds bank accounts, brokerage accounts. If you open new accounts, close new accounts, the trust acts like your alter ego in essence.
Okay. And the thinking is a trust lives on, even though you don't live on, right? That's
Correct.
why.
Yes, you as the trustee, while you're alive, have control and ownership over the assets, and then you nominate successor trustees who will have control and ownership over the assets for the benefit of your beneficiaries when you pass away.
Okay. If it's that simple, why is this a big deal? Like, why do people pay taxes?
Because a lot of people just they're misinformed, or they think it should be simpler. Like there are a lot of intricacies depending on what your situation looks like, but a lot of it just comes down to people not wanting to think about their death and like planning. There's actually statistically like the legal or the biggest reason people don't plan is they think like planning for it will make their death manifest quicker. So they just like don't want to think about that.
Got it. Okay.
Hey,
Thank you.
Brittany, correct me if I'm wrong here, but the revocable trust that will handle inheritance situations, but it doesn't provide asset protection or creditor protection. Is that correct?
It doesn't provide asset protection or creditor protection for the trust maker during life. It can provide asset protection and creditor protection for the beneficiaries.
Oh, okay.
Now, there are some states where you can set up what's called like a domestic asset protection trust, which can give you creditor protection while you're alive, asset protection while you're alive. But it's going to depend on what state you're located in and what type of assets you have that you're trying to be protective over. Because like California is just, for example, they don't have very favorable asset protection laws. So if all of your assets are in California, it's going to be really hard to achieve asset protection with just a trust. You're going to need to have a lot of LLCs and things like that.
And I'm going to throw one more question here. They're starting to stack up a little bit, and I'll let you go after this. But so you mentioned in the case that an LLC is a sole proprietor or one person is in the LLC. What if there's two members and it's their spouses? Is it the same situation or is that treated differently?
treated differently as it relates to.
Um, treated differently as it relates to, or maybe spouses and the kids altogether. You know, does that change going through probate?
As long as the LLC interest has been assigned by the members to their trust. So that's what we do. The LLC members will assign their interest to their trust so that the successor trustees, when something happens to those LLC members, can step in, and they have authority now to manage anything in the business. They could step into those members' shoes and close down the business and do whatever they needed to do without going to probate court. So an assignment is needed from the LLC to the trust to avoid probate court.
Gotcha. All right. Let's continue on. We've got 14 minutes left.
I'll try to talk as fast as possible. And maybe we just split this in half and do a part 2 meeting another time.
Somebody has requested you come back and focus only on single people and how
I would be happy to. So if you recall, 2 options for a married couple to plan at the death of the first of them, and then at the death of both of them. The same 2 options is that first, everything can go out to their children outright in their name. Once your kids receive their assets, their inheritance in their name, it's subject to all their decision making. Or the second option is you can transfer your children's inheritance in what I call a lifetime asset protection trust, which means from the outside looking in, it looks like they don't own anything, but it's an irrevocable subtrust that's part of the decedent's estate. You're the trust maker, and the beneficiaries can have as much or as little access to the assets as you want them to have. So prior to me being an estate planning attorney, I did a lot of personal injury. And the first thing I would do when I got a new case is I would do an asset search on the defendant. And if that defendant, if the person who hit my client owned a house or a business or had, money, I changed my negotiation strategies with the insurance company, and I would often threaten to sue their client personally if they didn't want to acquiesce to what my demands were. If I did an asset search and I was like, oh, these people have nothing, I'm going to accept whatever the insurance is willing, whatever the parameters of the insurance company has to offer. And so with this type of asset protection planning for your beneficiaries, in this scenario, from the outside looking in, if I were to do an asset search, it would look like your kids don't own anything because it never moved into their name. They are just the beneficiaries of a subtrust in your estate plan. So the pros of this is that, you protect your beneficiaries' inheritance from future lawsuits, creditors, bankruptcies, and divorces. It allows for flexibility in estate planning with the use of powers of appointment and generational skipping transfer taxes. And it allows you to have some control from the grave. The cons is that, there are some more administrative obstacles, right? So you're dealing with trusts and trustees for the duration of time that there's money in this trust. And for true asset protection, you have to give up some control in order to preserve asset protection. So we're going to have some examples here. So in an example, Harry and Wanda create a living trust with a lifetime asset protection trust created at the death of both of them for their beneficiaries. Harry and Wanda have 2 kids, Andy and Betty. 3 years later, Andy's 3rd wife files for divorce. Andy's inheritance is protected in one of these lifetime asset protection trusts. And so his disgruntled, soon-to-be ex-spouse can't access any of the assets that are in this trust. And 15 years later, when Andy passes away, under the terms of this lifetime asset protection trust, his inheritance has grown substantially, and it passes to his 3 children free of any death tax on Andy's estate, which is using this concept called the generation skipping transfer tax. In the interest of time, I'm not going to emphasize on that anymore. So the key takeaway there is that it's no longer enough just to do a living trust that forces on Andy's inheritance into Andy's pockets when Harry and Wanda pass away. A lifetime asset protection trust keeps Andy's inheritance protected and is designed to last beyond Andy's children and benefit Andy's beyond Andy's lifetime and benefit Andy's children. So what is a trustee? The trustee is the person who has the responsibility to follow the terms of the trust provided by the trust maker for the benefit of the beneficiary. They have three main duties. Their duty is to manage the assets in the trust, invest the assets in the trust, and distribute the assets in the trust. And it's the most important role that you can select for somebody, because if you choose the wrong person, it can lead to a variety of negative consequences, such as the mismanagement of assets, conflicts of interest, and breakdowns amongst benefit relationships of the beneficiaries, especially if you name a trustee who's also going to be a beneficiary. You have multiple kids, your name in order of their age, you're naming the oldest kid as the trustee. That trustee has like their hands on all of the assets. They can start making, decisions that the beneficiaries may feel are adverse to their interests, and it could cause conflict. So it's important that you are very thoughtful about that decision. So who serves as the trustee? While you're alive, you are the trustee of your trust. That means you have the ability to control the assets in the trust and change the terms of the trust at any time, as long as you have capacity to do so. And then when you die, your spouse becomes the sole serving trustee. And when you both pass, your revocable trust becomes irrevocable, meaning nobody can make any changes to your trust. And a successor trustee is named to handle the affairs for the beneficiaries. So when you set up these asset protection trusts, you in theory can think of it as like it goes, there are three bubbles, right? If you have three kids, each kid has their own asset protection trust. They can each be the trustee of their own asset protection trust. So they're the trustee and beneficiary of their own trust. You can choose anybody you want to be the successor trustee. As long as they're at least 18 years old, they are allowed to be a trustee. Now, would I name an 18-year-old as a trustee? Never. I usually counsel my clients that people should not be trustees unless they're at least like 30. Some clients give me pushback and they're like, no, my 18-year-old is really, really responsible. And I'm like, I don't think so. But that's on you. If you name your children as a successor trustee and it's an outright distribution, it's important that you provide clear and unambiguous instructions on how decisions should be made to avoid conflict and court intervention. This is really common when there's multiple kids and one real estate. You're almost always bound to fight over how that property should be handled. If you name your children as successor trustees of Lifetime Asset Protection Trust, it's very important that it's structured to provide flexibility so that they can remove themselves and appoint an independent trustee when they need to. And so here's an example. Harry and Wanda set up their trust so that Andy and Betty received their inheritance in this Lifetime Asset Protection Trust. Each child was a trustee of their own LAPT, and each Lifetime Asset Protection Trust was funded with a variety of assets to provide Andy and Betty with financial support while they're also protecting their assets. Betty is facing a lawsuit, and there's a risk that the assets within the trust may be targeted by creditors. And so the trust allows for her to step down as trustee temporarily and appoint a special independent trustee. So practically speaking, she would meet with her attorney and confirm she's allowed to do this. Then she can either choose like her attorney, or California is one of the only states that has licensed fiduciaries. And she chooses somebody to be the trustee of her trust temporarily. And now her new trustee has full discretion over the distribution and management of the assets until the legal threat is resolved. Here's another example, which we'll tie up here. Andy named the successor trustee of his Lifetime Asset Protection Trust. It allows him to make discretionary withdrawals of the principal and income. And when Andy's going through his divorce, Andy's divorce attorney tells him that it would be much better if he removed himself temporarily as the trustee and appointed an independent special trustee until the divorce is final. So Andy finds a professional trustee. And this is because if you are the trustee and you have discretion to take money in and out for whatever reason you choose, then the judge or creditor could say, pay me. And if you could pay yourself, you can pay the creditor. If there's a third party in there, the third party can simply say, no, we're not paying. And because you're not the owner, the trustee is considered the owner. The trustee can just say no to all of your creditors or your disgruntled ex-spouses. So it's really important that your trust is flexible enough for these types of changes. So, I don't want to
Brittany,
answer questions. Yeah.
yeah, actually, at this point, we've got 5 minutes left, and I want to make sure for the last 2 minutes you put your contact information up there, at least that amount. So it's your choice. Do you want to go on with the presentation or over to questions? We have more questions than we can fit in the time already.
Yeah, I'll take questions, and then I can come back for like the second half of my presentation.
Yeah. We'll invite you back. I think we have maybe one slot in December, and then the rest is in the new year.
Perfect.
All right.
Whatever questions, bring them on.
Yeah. So let's see. VC is asking, what are the minimum age requirements for a trustee? That's a quick one.
18. But like I mentioned, unadvisable to have an 18-year-old as a trustee.
Yeah. I chuckled pretty good when you said that. So Camilla is saying, not very clear on this comment. Asset protection is not that great in California, even if covered by a trust. Did I misunderstand? I would appreciate some clarification.
Sure. Single member. So this type of trust is mostly a tax strategy and probate avoidance trust. It's not really an asset protection trust for the person who is setting it up. It's good asset protection for your beneficiaries, for your for like anybody who is not the trust maker. But you, as the creator of a revocable living trust, are not going to have good asset protection with this type of structure. Now, from an LLC standpoint, California is still not a good asset protection state just because of the evolution of case law. Other states are just far more favorable for business owners than California. California allows for single member LLCs for the creditors to execute a charging order so they can step into your shoe as the member of the LLC and basically just pay off their credit interest, their debt. Other states, the way the case law has evolved is just more favorable for business owners than creditors. So I don't know if I'm confusing you there, but that's the short version of that answer.
So we have a lot of good questions here, and I would really highly recommend that if you have questions, you have Brittany's email here. Go shoot her an email, and you can follow up on that, I suppose, or Brittany, would you rather me collect them and send them over to you in like one email?
Either or, and really, I also will shoot you this link here where I offer free initial consultation. So if you wanted to just jump on that calendar for like a free call, happy to.
Okay. There's one question here that is, I think I'll be quick, but it is interesting. What's the typical cost as a percentage to name a legal firm as the trustee? And do you do that?
Yeah, so I try not to, because if I become the trustee, then I'm conflicted out in helping on the administration side of things. So it just becomes a conflict of interest. But from statutorily, there's a legal the law provides that trustees are entitled to compensation, and as typical lawyers who put laws together, it's fair and reasonable compensation. So whatever that means at any given time of what the fair market value is, but usually probably between, I would say, whatever the hourly rate is that what they're going to charge you to be their trustee. But if you go on like California's licensed professional fiduciaries, I think they charge anywhere between $100 and $200 an hour, slightly less than hiring like a law firm.
Okay. Hey, could everybody here take themselves off mute and give Brittany a big thank you?
Thank you very much,
Brittany.
Brittany.
Thanks,
Brittany.
Thank you.
Really helpful.
Thanks, Brittany.
Thank you, Brittany. Thank you very much.
Thank you.
Thank you.
Good,
Welcome.
Thank you.
good presentation.
Oh,
Thank
thank
you.
you. I appreciate that. And truly, I'm open to helping answer any questions that you guys have. I'm sorry we ran out of time. But whatever questions are kind of most common amongst everybody, that will help for the next presentation to kind of make it
Yeah.
a focused talk.
We'll find a time to schedule that in.
Cool.
And next week, we actually just had our speaker canceled from next week about an hour ago. So we'll see what we do. But we'll see you all here. It's every Friday at noon Pacific.
Okay. Well, thank you guys. Have a great rest of your weekend.
Thank you.
You too. Thanks, Daniel.
Have a great weekend, everybody.
You too.